It's an honor to be at SMU today for Founders Day. SMU is one of the most beautiful campuses in the United States. SMU has an outstanding faculty, and SMU has an exemplary student body. Every time I walk through the campus of SMU, I always think about Dr. Hal Williams' history class and the way he taught that subject with such knowledge and passion. I think about Dr. Baker and his EE 1305 class and the way that Dr. Baker truly cares about his students and takes an interest in their lives. I also think about Dr. Cohen's physics class. Great class, but unfortunately, it met at 8 o'clock in the morning. 8 o'clock sharp, not 8:01. It's the people that make SMU great. It's you folks who make SMU great. I'm proud to be an alumnus of SMU. My name is Blake Norvell. I'm an attorney who practices law in Texas and California. I will entitle my remarks today, NSA Warrantless Wiretapping, a Fourth Amendment Violation, ? On September 11, 2001, America suffered the most devastating attack ever perpetrated on U.S. soil. In response to the tragic events of 9/11, President Bush authorized the NSA, the National Security Agency, part of the executive branch, to begin monitoring the international phone calls between persons residing in the United States and persons residing in foreign countries believed to be affiliated with terrorist organizations. The public became aware of the program in December of 2005, and the New York Times ran a report on it. While the government has never revealed the precise details of the program to the public, it's undisputed that the NSA warrantless wiretapping programs allows the NSA to monitor international phone calls and emails without first seeking a warrant from a neutral judge. Some legal scholars contend that the NSA warrantless wiretapping program is clearly unconstitutional, while others, characterizing the program as foreign surveillance and pointing to the fact the president has broad authority in this area, argue that the program is in fact constitutional. The fact that legal scholars vary, their opinions vary widely on this subject, indicates it's a difficult legal subject. It's a legal topic in which reasonable minds can differ. Nonetheless, even with topics in which reasonable minds can differ, often a stronger view or a better view of the law will emerge. This lecture will address the issue of if NSA warrantless wiretapping violates the Fourth Amendment of the Constitution by examining various cases and policy issues. In other words, this lecture will address the difficult but rather important question of if NSA warrantless wiretapping violates the Fourth Amendment of the Constitution. Because the government hasn't revealed the precise details of the program to the public, the lecture will construct two hypothetical models that will approximate how the program likely functions in reality. One is the broad, expansive version of the program. The other is a more narrow, less expansive version of the program. The differences between these two versions of the program is constitutionally significant. The expansive model of the NSA warrantless wiretapping program consists of two elements. The first element is the NSA places a wiretap on a foreign terrorist in a foreign country overseas and monitors all calls to and from his phone. That's the first element. The second element, the expansive version of the program, is the NSA places a wiretap on a United States citizen living in the United States suspected of terrorism and monitors all of his international phone calls. That's the expansive version of the program. The narrow version of the program, on the other hand, consists of one element. The NSA places a wiretap on a foreign terrorist residing in a foreign country overseas and monitors all calls to and from his phone. In other words, under the narrow version of the program, the only way that a caller from the United States is recorded is if he either receives a phone call from a foreign terrorist in a foreign country or he calls a foreign terrorist in a foreign country. The critical difference between the broad version and the narrow version of the NSA warrantless wiretapping program is that under the narrow version of the program, the target of the search is always a foreign terrorist living in a foreign country overseas, never a United States citizen. By contrast, under the expansive version of the program, the target of the search can be a United States citizen living in the United States who's suspected of terrorism for a warrantless wiretap pertaining to international phone calls. This lecture will demonstrate that the narrow model of the NSA warrantless wiretapping program is constitutional. The expansive version of the NSA warrantless wiretapping program, on the other hand, is unconstitutional because it violates the Fourth Amendment. This lecture will also emphasize the critically important role that the neutral judge plays in standing between citizens and the government in protecting cherished Fourth Amendment privacy rights. Let's apply the Fourth Amendment to the NSA warrantless wiretapping program, shall we? There, right before you, is the text to the Fourth Amendment. It's taken word for word right out of the Constitution. As you read that, you'll notice there's a search requirement. It means that a search must take place for the amendment to be triggered. Second, there's a warrants requirement. A way to paraphrase the Fourth Amendment might be to say something to the effect of, if the government wants to conduct a search, the government needs to obtain a warrant from a neutral judge. Why did the Founding Fathers pass the Fourth Amendment? The Founding Fathers passed the Fourth Amendment as a prohibition against general warrants. General warrant occurs when an officer of the law or member of the executive branch conducts a suspicionless search in mere hopes of finding a violation of the law. For example, imagine you're at home on a Saturday and a policeman knocks at your door. He tells you that he's going to search your home, not because he thinks you've done anything wrong, rather he just wants to go in your house and look around and hopes that he can find something you've done wrong and arrest you for it. That's a general warrant, and our Founding Fathers found them contrary to freedom. Let's apply the warrants requirement of the Fourth Amendment to the NSA warrantless wiretapping program. In the landmark Supreme Court case of Katz versus United States, the Supreme Court held that wiretapping constitutes a search under the Fourth Amendment, and the government must get a warrant absent a very well-defined and specific exception to conduct wiretapping. On the other hand, the Katz case was a case about enforcing the criminal law. Defendant Katz was charged with using transmitting bets via wire. Clearly, in Katz, national security is not implicated. Another very important Supreme Court case is called United States versus United States District Court, also called the Keith case. This is a case in which a warrantless wiretap was utilized domestically solely for the purpose of protecting national security. This is a classic domestic terrorism case in which individuals were charged with using dynamite to blow up a branch of the CIA. Supreme Court held that even in national security cases, the government is required to get a warrant to conduct wiretaps. The court emphasized that official surveillance, whether its purpose be enforcing the criminal law or protecting national security, threatens the liberty interest of the American people. In other words, the Supreme Court said even if the government's conducting national security surveillance, it needs to get a warrant signed by a neutral judge. On the other hand, the Keith case or United States District Court did not involve any international communications. NSA warrantless wiretapping, by definition, involves one party in the United States and another party overseas abroad. Therefore, a valid question remains if the distinction between domestic and foreign surveillance matters for Fourth Amendment purposes. To answer that question, consider the following. Domestic terrorism and international terrorism pose about the same threat level to the United States. 9/11 was very tragic. The Oklahoma City bombing was also very tragic. Second, people who place international phone calls from the United States have an expectation that the United States government will not monitor their phone calls without a warrant because it doesn't monitor their domestic phone calls without a warrant. In other words, from the U.S. side, there's a reasonable expectation of privacy on international phone lines. Third, the same type of abuse that's present if the government is allowed to wiretap domestically without a warrant for national security purposes is also present if the government is allowed to wiretap calls placed from the U.S. side internationally for national security purposes. Therefore, the following rule of law can be derived from Katz and U.S. District Court pertaining to NSA warrantless wiretapping. This is important. Do you have a pen handy by chance? If you do, write this down. I'm going to give you the law on NSA warrantless wiretapping in one sentence. Government surveillance programs aimed at either protecting national security or enforcing the criminal law must comply with the warrants requirement of the Fourth Amendment when one party to the conversation is within the United States if the party in the United States is the target of the search. That's the black letter law on NSA warrantless wiretapping. So what this means is that under this rule and under Katz and U.S. District Court, the expansive model of the NSA warrantless wiretapping program is unconstitutional because it violates the Fourth Amendment. Allowing essentially the expansive model of the program hands the NSA a general warrant, the very warrant the Fourth Amendment was passed to destroy. After all, under the expansive model of the program, the NSA decides who to wiretap, when to wiretap, who to listen to, how long to listen to, and so on and so forth. The privacy interests of the American people belong in the hands of the neutral judge, not in the hands of covert NSA officials. On the other hand, under the narrow model, the program does not violate the Fourth Amendment because these concerns disappear. Nobody is concerned with protecting the privacy interest of a foreign terrorist residing in a foreign country overseas. The role of the neutral judge is to stand between citizens and the government, not to stand between the United States government and a foreign terrorist and a foreign country. Therefore, a court's likely going to find that the expansive model of the program is unconstitutional, whereas the narrow model is constitutional. Indeed, a holding that the narrow model of the NSA warrantless wiretapping program violates the Fourth Amendment would not only be inconsistent with precedent, but it would defy rationale. What it would mean is that the government is free to monitor foreign terrorists in foreign countries, except when such monitoring is most likely to prevent a terrorist attack. After all, and if a terrorist in a foreign country wants to bring harm to the United States, he's likely to call a fellow terrorist in the United States for help. That is the very conversation that the NSA does need to be listening to. However, even if a court were to find both models of the program violate the Fourth Amendment, that doesn't end the inquiry. The next question becomes if there's a Fourth Amendment exception that could apply. There are two possible Fourth Amendment exceptions that could apply to NSA warrantless wiretapping. The first is the special needs exception, and the second is the possibility of a foreign surveillance exception. Let's talk about special needs. The Supreme Court will grant a special needs exception from time to time when the government has a special needs beyond enforcing the general criminal law. For example, highway sobriety checkpoints done for protecting public safety rather than arresting drunk drivers is an example of a special needs exception. And you can see there's several special needs exceptions, but there are three justifications the court utilizes to grant them. The first justification is the targets of the search are randomly selected. This applies to the narrow version of the program because from the U.S. side, whoever calls a terrorist or receives a call from a foreign terrorist is random. The NSA can't know that in advance. But by contrast with the expansive version, it doesn't apply because the NSA must target someone on the U.S. side for monitoring. Second exception, the intrusion into privacy is minimal. That doesn't apply to either version of the program because by definition, wiretapping is highly invasive. The third special needs justification, the targets are a member of a class with a legally binding reason to have a lower expectation of privacy. That applies to the narrow version of the program. A foreign terrorist living in a foreign country has no Fourth Amendment rights whatsoever. On the other hand, with regards to the expansive version of the program, it doesn't apply because most terrorists who are in the United States go out of their way to comply with the law and remain under the radar screen. Therefore, the special needs exception applies to the narrow version of the program, but it won't save the expansive version. Now, let's talk about the possibility of a foreign surveillance exception. Arguably, the NSA warrantless wiretapping program is a foreign surveillance program. So the question becomes, is there a foreign surveillance exception that would apply? Understand, a foreign surveillance exception would legalize both the expansive and the narrow version of the program. The circuit courts have addressed this question, and they've issued split decisions. The D.C. Circuit, emphasizing the importance of the neutral judge, held there is no foreign surveillance exception to the Fourth Amendment. On the other hand, the Fourth Circuit Court of Appeals, arguing that judges are not schooled in national security matters, whereas the president is, said there is, in fact, a foreign surveillance exception to the Fourth Amendment. Which court is correct? Protecting national security and protecting cherished Fourth Amendment privacy interests are both compelling interests. I have 6 on the one hand and the half a dozen on the other hand. This is a close call, almost too close of a call to make. Ooh, I'll tell you what. Here's the answer. The D.C. Circuit, which held there is no foreign surveillance exception to the Fourth Amendment, holds the better view of the law. How do we know that? Why? The only reason we can make that determination is because of the existence of the Foreign Intelligence Surveillance Act, FISA. Without FISA, this would be too close of a call to make. See, FISA allows the president to quickly receive a warrant in national security matters from a judge who's schooled in national security matters. So because of the existence of FISA, a foreign surveillance exception to the Fourth Amendment is not necessary. Understand that FISA offers a fair but imperfect compromise. FISA provides a neutral judge, but FISA allows him to issue warrants without probable cause. That's the FISA compromise. There's another reason that a foreign surveillance exception to the Fourth Amendment is not necessary, and that's the court's current view of the law. The court currently views the Constitution as a document that protects citizens rather than restrains the action of government. This means that the Fourth Amendment does not apply overseas. In other words, when the CIA is monitoring two individuals in a remote corner of the world, the CIA doesn't need to get a warrant from a neutral judge. So because of the court's current view of the law, a foreign surveillance exception to the Fourth Amendment is not necessary. Therefore, a foreign surveillance exception is not necessary for the narrow model to operate, and the expansive model of the program would not be saved under the theory that there exists a foreign surveillance exception. So the bottom line is the narrow model of the NSA warrantless wiretapping program is constitutional and would be upheld by our courts. The expansive model of the warrantless wiretapping program is unconstitutional and likely to be declared so by our courts. Now, I know a lot of you have a lot of interest in this topic, so if you want to read further on this, I'd urge you to read my article published at Yale Law School on this subject. It's been a pleasure visiting with you. I want you to enjoy the rest of your Founders Day, and as always, go Mustangs!